Okay, so in the interest of time, I am going to get started. My name is Fred Barstein. I am the editor-in-chief at 401k TV and CEO at TPSU, the Plan Sponsor University. Welcome to our first master class on 401k TV. Just wanted to explain a little bit about the master class. We have done close to 150 half-day training programs with plan sponsors around the country since May of 2013, and we're in December 2015, we launched 401k TV, and what we're trying to do is take some of the information and learning and education that we've successfully conducted in person and bring it onto 401k TV through our daily newsletter, which is free if you sign up and register, but also through our first master class. And so the first class that we're conducting is called The Rash of 401k Lawsuits, Navigating Dangerous Waters. And one of the reasons that we started with this subject is because it's the most popular. The articles about litigation are the most popular on 401k TV. So I'm going to just start with a few opening remarks, introduce our panel, have our panel do a few opening remarks themselves, and then we have two major sections of this master class. One is reviewing the major themes for the lawsuits, and we're focusing on lawsuits where the plan sponsor is involved. There's a number of lawsuits that are against the record keepers, the providers, the money managers, and we're not going to have time to focus on those. It's really those against or where the plan sponsor is involved. We are then going to move to how can you protect yourself against these lawsuits with comments by Tom Kamak and followed by our other two panelists, and then we will have some closing remarks. If you do have questions along the way that you'd like us to address, we will do that at the end. Just type them in on the WebEx screen. So before I introduce our esteemed panel, I wanted to just a couple of opening remarks, which is everything seems a little bit different now. It seems like there's been a whole spat of lawsuits, and they seem to be maybe going in some different directions. Some of the themes might be the same. And I wanted to, really dive into why is that happening, what's causing this, and what we can look for in the future. One of the things that I really noticed in the beginning, almost 10 years ago when the lawsuit started, especially against the providers, they were really defending them vigorously, almost spending twice as much money to defend the lawsuit as it might have been to settle, or even then the case was worth, because I think they were really trying to make a point and really stop them. But I think that with more wins against them and more case law and more precedents, we're seeing more parties maybe settling, but we're also seeing not only the attorneys who are winning, and one of the probably the most prolific firm is the Schlichter, Bogart and Denton firm, Jerry Schlichter. They're learning more. They're seeing more opportunities, and I think they're also, we're seeing other attorneys come in and follow suit. So it just seems differently. And before we get into the meat of our master class, I wanted to have our panelists say some opening remarks. Before they do, I wanted to introduce them. So our panelists include David Levine, who is a principal at the Groom Law Group, which is headquartered in Washington, D.C. He advises plan sponsors, advisors, and other service providers, focuses on, among other things, in-depth compliance reviews of corporate and government programs. He's the chair of the IRS Advisory Committee on Tax-Exempt and Government Entities, or he was from 2011 to 2013. He's a regular speaker, and he has his JD from the University of Pennsylvania Law School. Tom Clark is of counsel at the Wagner Law Group, which is a law firm that specializes in ERISA and benefit law and employee benefits. He focuses on compliance of retirement plans and a robust practice assisting service providers. But one of the reasons we wanted Tom Clark on the call is he had, in a prior life, worked for the law firm of Schlichter, Bogart, and Denton, and worked on one of the landmark cases, Tibble versus Edison, which was decided by the Supreme Court. He writes a wonderful blog called Fiduciary Matters blog, which has been visited over 160,000 times since publication. And he teaches ERISA law at Washington University, St. Louis School of Law, which is his alma mater. And last but not least is Tom Kamak. He's the CEO and co-founder of Fiduciary Benchmarks, which has really become the premier benchmarking services for defined contribution plans. And they're helping fiduciaries to determine whether their fees they're paying are reasonable, which is a big one of the issues that's coming up in the lawsuits. Before starting Fiduciary Benchmarks, Tom started J.P. Morgan Retirement Plan Services, originally with American Century, and then moved over to J.P. Morgan. It has since been acquired by Empower Retirement. When he left in 2007, the company had 1,100 people serving 200 large plan sponsors with over 1.5 million participants and 115 billion in assets. And Tom is also a regular speaker. And I go to all the conferences, almost, and I hear all the speakers. And these are the three best that I thought could really give some perspective and insight and also some practical advice on these areas. So without further ado, I will let our panelists chime in here now and give some opening remarks on what they're seeing and why it seems a little bit different now. So, David? I'm sorry, David, you may have to unmute your phone.
Sorry, I apologize. Make sure I am unmuted.
Yes, you are. I can hear you now.
Sorry, my apologies. Good afternoon, everyone. Thank you for joining us. So definitely we are in a different world these days. I think Fred is right. Things feel different, and let's try and talk. I'll try and talk for just a minute as to why. First, I think we live in a data-driven world today, and the information about plans is more accessible than ever. You can search on the DOL website or on the internet. Plaintiffs' lawyers, between Facebook and other activities, can reach out and touch people faster and gather information. Second, you're seeing an evolution where the small group of plaintiffs' firms who have had some good success and gotten these so-called eye-popping judgments that oftentimes I encourage people to look beyond, but eye-popping judgments still draw people in. And as a result, you're seeing other players come into the field. Third, the thing that I think why it's different is it's a race to the courthouse. This is the classic for anybody who's ever watched on TV. No fee until we settle, almost like a personal injury lawsuit. And what's happening is you have many players. You have many law firms who say, I can make money at this. Other areas of class actions have been shut down. We've all seen how our credit cards, cable bills, and everything have arbitration clauses. ERISA is a money mill by comparison. So what is happening is the plaintiff's lawyers have the data, information, the accessibility to your participants, and they also see that there is an upside with frequent settlements. As Fred said, settlements are more common now. People are more likely to settle than to fight it out, which is just a witch's brew that leads plaintiffs' counsels to pour into this industry until the tide shifts again. But I'll keep it brief to keep us on schedule.
Thanks, David. Tom?
Thanks, everyone, for being here. I'll play a counterpoint to David's point. We certainly have seen a very increased number of lawsuits filed in the last 6 months. I'm currently tracking over 60 of them for publication on the blog. I don't write about all 60 at all times. There's 60 different cases that I'm constantly getting new filings on. I will counter David in saying that while it seems that there are new cases, these cases are incredibly expensive to litigate from the plaintiff's perspective. Experts cost, lots of money. The going through the data and the documents cost lots of money. One of the last cases I ever worked on at my previous firm had over 10 million or 5 or 10 million pages of documents in it. So while a lot of plaintiffs' firms may be getting into the game beyond the core group that has litigated these cases over the last 10 years, for some of the new ones who think that it is going to be a money mill or an easy road, I think they are going to be surprised at how very sophisticated the ERISA defense bar is, including lawyers in my firm and lawyers at David's firm and other major firms around the country. There was a time when the most sophisticated ERISA litigators were the defense lawyers, but those firms that have been around for 10 years, I think, have caught up, and we'll discuss in the cases today ways in which they've caught up in knowledge. And so what I would put out on the table is that the new players, they are going to have to play catch-up for a very long time. It's not simply being able to read the orders and the decisions and 5500s from the other cases, but it's going to require them to set up, have a deep bench of litigators who have the sophistication and the knowledge to be able to litigate these cases, as well as the war chest to pay for them.
Thanks, Tom. And Tom Kamek?
Thank you, Fred, and thanks for having me part of this prestigious panel. I'd like to say I've been doing this for about 32 years now in the retirement business since 1984, when we used to terminate defined benefit plans and install 401k plans with a match so often we called them option one. But, I've never seen anything like this, this type of litigious frenzy. And as I looked at Drinker Biddle, another prestigious ERISA law firm, look at the different cases, I was amazed at the lack of value. And then I started to total up the numbers, and I figured out that there's about $204 million in attorney's awards that have been given, and about the average participant is getting about $116. And in fact, when I read the blog of one of the companies that has been sued, the people were, the actual participants were deriding how much money they had gotten from the settlement. So, I understand what Tom Clark is saying, but $204 million in plaintiff's awards to the attorneys is a big number. And the other thing that I think is different that I haven't seen is that as I looked at it, I really saw, at least we couldn't find a lot of discussion of the value side of the equation. So if you're a plaintiff's lawyer and you're arguing the fees should be lower, and the only thing you're concentrating on is the fee, and we're actually involved in another case right now where we're actually trying to bring the value side of the equation in. 3 is less than 4, 2 is less than 3, 1 is less than 2, 0 is less than 1. That's a pretty easy equation. But when you start to introduce other variables like value, it makes the actual litigation process even more difficult for the plaintiff side. And I believe that the industry is going to have to rally around that value side, because otherwise it's going to be a race to the bottom. And if the value side is there, it can be a win-win-win for everybody. So this is not like anything I've ever seen in my 32 years.
Great. Thanks, Tom. And so why don't we get into our first section, which is the major themes around self-dealing, which we're going to have David Levine open up about.
Sure. And I think the best way to talk about self-dealing is to understand the rules a little bit, because so often we read these lawsuits in the paper, and the first thing that we think about when we see them is, okay, what went wrong? Why is there so much money at stake? What's the mistake? But even as lawyers, when we start talking, we oftentimes have to think, well, what does this all come out of? What is the rule on self-dealing? Well, under ERISA, to really go to a very basic framework here, the idea is that ERISA fiduciaries, which could be you at your company, it could be the company itself, which is less and less common, but it has historically been the company, or it could be a committee, and we'll talk about ways to potentially insulate yourself later. But the key thing is a fiduciary of a plan has a very high standard of obligation to participants and beneficiaries. It's the highest standard known to the law, if you quote an old case from the courts. The key point of this is if you're an ERISA fiduciary, you have an obligation to act for the exclusive benefit of participants and beneficiaries, and not to act for your corporate interests. And the plaintiffs' lawyers have quickly turned, and this is where they began in a lot of cases, with the concern from their perspective that plan sponsors and plan fiduciaries weren't really acting for the benefit of the participants and beneficiaries, but they were trying to help the company and help move it along. So what does that really mean? Well, we begin with one basic starting point. Under ERISA, there's a definition of fiduciary. It's section ERISA 321. I'm not going to bore people by citing things over and over. But under ERISA, also service providers to plans are so-called party in interests. Is it worth diving super deep in the weeds on this today? No. The key thing to keep in mind is both fiduciaries and party in interest can be involved in what are called prohibited transactions. Prohibited transactions are basically the rules in ERISA, and ERISA at times feels like a backward statute that says all these things are not permitted under ERISA, including paying people or giving people assets of your plan to invest potentially in some cases. So there's all these exemptions. So you first say, is this prohibited and is there an exemption? The classic example is hiring a service provider. If you hire fiduciary benchmarks and you were to pay them out of your plan as assets, technically that's not allowed, but for the fact that there's the so-called Section 408B2 fee disclosure rules, and which is an exemption that says you can pay for that. Similarly, there's a whole stack of exemptions. It's 15, 20 exemptions at this point that are built into the statutes. The key thing is to keep in mind is when you look at a prohibited transaction, there's sort of two basic pieces to think about here. First, there's the so-called party and interest ones. These are the ones where you hire someone, pay them money, invest assets, and these assets and these things that would otherwise be barred can generally be addressed by disclosure, by paying reasonable compensation, for instance, is the most common one. But if you disclose your compensation and it's reasonable, it's okay. However, there's a second set of prohibited transactions, the so-called self-dealing ones, where if you are a fiduciary of the plan, so if you are in charge of running the plan, selecting your vendor, selecting investments for participants to invest in, if you are a fiduciary, what happens is that you have, in a sense, per se prohibitions. If you enrich yourself to the detriment of the plan, disclosure doesn't get around that. There's lots of ways to approach it, and it's a very complex process, but it doesn't get around it. Similarly, if you get a kickback, and a kickback could be where a vendor pays you something that doesn't benefit the plan, that's a prohibited transaction violation as well. That's a so-called 406B of ERISA violation. So let's talk about how this plays out a little bit as we move forward. So Tom is going to talk about a number of cases as we move forward here, Tom Clark is. So let me try for the next just couple minutes to talk about a little bit of a case study. Tussey versus ABB. It's one of the earlier cases about a self-dealing case. In Tussey, there were a number of claims. To boil it down to its simplest for this discussion for the moment, there was a question over record-keeping fees. How much was being paid to the record keeper for the plan? It was a question over investment selection, the right investments, did it align with plan policies, and how much were these investments costing? And then there were some issues also about the vendor itself, which was Fidelity, but any firm could be sued as part of these, as Fred alluded to in his introduction. And they were sued on something called float. We're not going to spend time on that at this moment today. So in Tussey, it went up and down through the courts. And Tom's point he made earlier that it costs a lot to litigate, Tom Clark, is absolutely true. Tom Kamak makes the point that there's large settlements, absolutely true. And this is a great example of where it costs a lot of money to go through the courts. In the end, Fidelity on its float issue managed to escape. But ABB on record keeping did not escape. Investments, it escaped effectively on a technicality. But the key point about this is there are some lessons to take away. ABB, to really focus on one core point for just the moment, ABB basically was accused of selecting a vendor like Fidelity and getting other services like record-keeping services, but other services like payroll for the benefit of the company. I just went through the exclusive benefit requirement that applies to a fiduciary. That's the issue, and the plaintiffs jump on that. They will say if you benefit the company, that is a concern because really you're using the investment of the plan's assets and the plan's money to pay Fidelity to enrich the company. I will note that this can manifest in different ways. It could be in different allowances you get from a record keeper, and it's important, one other thing to keep in mind as you look at this, that these costs are also could show up in shifting between multiple types of plans, so-called fee stacking. You can get representations from record keepers saying that, okay, this is what the plan would cost on its own, but that's important. I'll take 30 seconds to talk about this last thing. On service providers in self-dealing, you should be looking at consultants. They could be fiduciaries. They sell themselves as fiduciaries. Look to see, are they getting revenue and other compensation as they go along? Record keepers, we just gave the example of how they enrich the sponsor. Record keepers can be enriched as well depending on their arrangements. But their world has gotten more transparent, but you as fiduciaries have a duty. I'm not going to go deep on the product providers and other service providers, managed accounts, everything like that is out there now. The key is it's important for you to say, if anybody else could be a fiduciary, if you're selecting them, are they thinking about where there's conflicts and enriching themselves and not benefiting the plan? But with that said, I'll hand over to Tom Clark.
Thanks, David. So the cases David are discussing, these self-dealing cases, this wasn't necessarily the first wave. There were so Fred mentioned earlier this has been going on for about 10 years. My old firm filed a number of cases on September 11, 2006, a number of subsequent cases thereafter over the first few years, and then frankly recently has gone on another swing of cases. What I mean, so let's explain what old is new again. So in the first round of cases, there were a few self-dealing cases. David covered one that was filed. There were some others that settled early on. But a theme of a lot of the original cases were that not that the fiduciaries were enriching themselves, but the fiduciaries were just doing a bad job. They were, quote, asleep at the switch. They didn't have the best investments, or they had bad investments because they had no process to look at good investments. They had high fees. They hadn't looked for low fees. It wasn't that they were routing the fees to themselves. It's just that their plan wasn't as good as it could be. And many of the original complaints in the cases were very broadside attack. They were had many allegations, including that mutual funds per se should not be used, or an argument very close to that, or that you shouldn't have 300 funds, or that revenue sharing per se was bad. And these cases lost in front of the courts in the very beginning. One of the most famous ones, you can switch slides, Fred, is Hecker versus Deere. That lost in front of the district court in Wisconsin, lost in front of the Seventh Circuit, and the Supreme Court declined to take it. And there were a couple of other sister-related cases that had similar claims that also lost against Exelon and Unisys. And the litigation in favor of these participants in this excess fee litigation didn't look very good back during that time period, maybe between 2007 and 2009. But then a funny thing happened that led to the cases that David is talking about, the success of the self-dealing cases. It was a decision against Walmart, Braden versus Walmart out of the Eighth Circuit. And it was dismissed at the district court originally, and then went up to the Eighth Circuit. And the Eighth Circuit was able to say, no, we kind of like these claims of self-dealing. We think that the lower court improperly dismissed this without allowing discovery and without allowing facts, and we're going to send this back to be litigated. And it was sort of a watershed moment in the excessive fee litigation, because from then on, the complaints that were filed, the complaints that were modified and amended, they started going in the direction of self-dealing. And so that makes sense, right? If you understand the audience, which are federal judges, you understand that you don't get a lot of time in front of them. They usually have very heavy, busy dockets. And so your case, they're certainly going to do their best to give you their attention. But if they did not seem to respond well to cases simply saying that, well, this fiduciary didn't do a good enough job. And so the cases that simply allege that seem to not go anywhere. The cases that allege self-dealing have been very successful. Look at the fact from Tom Kamak earlier, $204 million or over $200 million in attorney's fees awarded. So these cases, the self-dealing cases, have been going on for a while, varying levels of success, a lot of settlements, some trial wins. And then a funny thing happened in the last 6 months. We're starting to see a sleep of the switch cases filed again. I think the biggest broadside case was this Bell versus Anthem, where Anthem was using Vanguard funds and using Vanguard as its record keeper, but the problem is they were in a more expensive share class. And so the plaintiffs say that when they went through some type of record-keeping analysis or RFP or something a few years ago when the fees were lowered, the basic argument is, well, you could have had them lowered earlier. That's an interesting case, right? There's no allegations that I could see saying that Anthem was in bed with Vanguard or was somehow getting any sort of kickbacks or anything of that nature. It was the case boils down to Mr. and Mrs. Fiduciary, you just didn't do a good enough job, and and even whatever you did, it wasn't good enough and it wasn't fast enough. And of course, these cases are based on plans with billions of dollars in assets, right? And we all know that jumbo plans have more economies of scale than smaller plans, and thus the lesson to take from there is, we don't know how these cases are going to be seen again in the courts. Maybe the courts, in light of all of the case law development that's happened in the last decade, decide that that's a valid claim and they like those allegations and they're going to allow them to move forward, and ultimately either at trial or on summary judgment they're going to agree. Or maybe they go back to where they used to on the Hecker versus Deere decisions and say, no, you know what, we're just not comfortable with cases where the allegation is mainly you just didn't do a good enough job. We won't know for a while, but what we do know right now, and what I can tell all my clients, and I'm sure David is telling all of his the same, is that the bigger plan that you have, the more of a bullseye that you're going to have on your back. And rightly or wrongly, those are the facts those are the facts that we have to deal with. And again, that stems from the more assets you have, the more purchasing power you have, the more heft you have in the industry, and you could make the providers give you products or pricing that they aren't necessarily inclined to give you on a first offer. So the big takeaway from these cases is that you need to be paying attention to the issues you see in this case. Share class issues, record-keeping expenses. Are you using stable value or money markets? And look at all these issues. Look at your plan. And frankly, any plan that is approaching $50 or $100 million, they may not necessarily yet be the subject of these lawsuits, but a $100 million plan can do incredible things that a $10 million plan can't in terms of its pricing. So on that, I will turn it over to my friend Tom Kamek.
Thank you, Tom. Thank you, David. Great review of all the various cases that have gone on. What I'm going to do now is spend a little bit of time talking about the two ways to protect yourself. And the first one, of course, is a request for proposal, which was actually mentioned in the Kraft decision. And I want to take a look at this like you would any project, scope, time, budget type of thing. The timing of RFPs, you'll typically see that 3 to 5 years. The scope of an RFP, whenever I think about, a benchmarking or fee comparison exercise, I try to think of it in terms of 5 simple steps. Number 1, let's get an apples-to-apples comparison. And number 2, let's then take a look at the quality, the service, and the value, which, frankly, the DOR wants you to do. And then number 5, once you understand those value components, let's move on to the fee side. So when I think of the scope component with respect to, an RFP, you're typically going to get 5 to 6 providers to make sure you get an apples-to-apples group, people that can do the work on those plans. The quality is very thorough, but the service side is only for your plan. So if you're taking a look at an RFP, you don't know if you're requiring more services than other similarly sized plans. You don't know whether the value is also only for your plan. You don't know if your participation rates are higher, if your deferral rates are higher, if your investing behavior is better. And then finally on the fee, you're also only looking at the fees for your plan. You could, of course, argue it doesn't matter because as long as I have the RFP fee, it doesn't matter. But it's a bit more myopic in nature. And, the schedule for an RFP, typically 3 months. The budget, you'll see numbers anywhere in the marketplace of $25,000 to $75,000. But the one point I want to make at the bottom of this RFP box is, if you are having service issues with your client, your record keeper for your clients, or If you're you get in the feel that the service provider isn't looking out for you as a fiduciary, if you get the feel that they're not trying to help your people retire, I wouldn't wait 3 to 5 years. I'd RFP the thing today and make sure you're getting what you and your participants deserve. On the benchmarking side, the timing is, we're seeing annually for the larger plans at fiduciary benchmarks, less frequently for the smaller plans. On the scope side, going through the 5 steps comparisons, we typically put 25 to 30 similarly sized plans. You get the benchmark group as narrow as you can with about 10 different record keepers, so the number of comparisons is broader. The quality isn't as thorough as the RFP, because with an RFP you're actually seeing what all the different service providers would do. But you do get the benefit of seeing how the services for your plan compare to other plans. It's not myopic, it's much broader, and the same on the value side and the same on the fee side. The scope gets broader as it looks at it. And in our mind, the best way to think about benchmarking is, there's 2 P's we put on it. It should be proactive and it should be in partnership. So there's 2 ways to do this, RFP and benchmarking. Both are absolutely viable. Both should absolutely be used, and they serve very important functions in the marketplace. Next, Fred. So as we talk about, I'm going to spend a little bit more time on benchmarking now and some of the things that we've learned. So on the right data side, one of the things that David said earlier, there's a lot of information available in the marketplace now, especially with the Form 5500. We've done some extensive testing of people that try to make certain conclusions from the Form 5500 regarding participation rates or deferral rates or things of that nature, and then we compare them to the way that, say, the IRS would want you to do an average deferral percentage test, and we find that you can't quite get there in many cases from the Form 5500. So in our mind, the data has to come from the service provider, and it should be very consistent with what's on the 482 form. From a process standpoint, you really want something that's procedurally prudent. You're not looking for something that's a marketing type vehicle. You're looking for something that would very much stand up in a court of law if you actually had to sit on a witness stand. So for example, we had Drinker Biddle, another prestigious law firm in addition to the ones represented by the 2 gentlemen on this phone, go through and look at, is this a procedurally prudent process? And then, as I said before, on the quality and the value and the service side, it's funny, there's a DOL handbook on fees, and you can print it off the DOL handbook's website, and off the DOL website it says, don't consider fees in a vacuum. It's only one part of the bigger picture, and make sure you include the extent and quality of the services provided. So here you have the Department of Labor admonishing you to not just look at fees, and that's because we can mathematically prove to all the people on the phone today that low fees do not trump better savings rates. Low fees do not trump better investing behavior. Low fees don't trump many, many other items. So it's really important that the benchmarking essentials contain basically the right data, a good method, and good output, right? Because that's, in effect, the entire exercise. The other thing I want to say is I looked at the key lessons from the lawsuits as Drinker Biddle summarized all these for us. Reasonable but lower fees expected. Use of an independent consultant advisor. Tom Clark's firm, the Wagner Law Group, was one of the first ones to publish a great article about the findings of what happened after the Caterpillar suit, which was use an independent opinion. RFP required periodically. Inclusion of index funds, avoiding conflicts. Again, a prudent documented process. I've heard folks like David and Thomas say many times, being a fiduciary is much more about the process than the result. But the key thing that I took away from this part is I read all of these components summarized for us. I came back to that commercial from old time ago for Wendy's, where's the beef? I could literally find no value components on it, and it's a very simple job for the plaintiff's lawyers to say, well, 4 is less than 5, 3 is less than 4, et cetera, et cetera. But if all of a sudden now there's an element of, but our deferral rate is 100 basis points higher, and our people are all invested in the right funds, and the leakage from the plan is really down, and boy, we do a lot more. We ask the record keeper to do a lot more work because of the merger and acquisitions that are typically done versus others in a benchmark group. Now it's a much more difficult equation, and in fact, as we said, the big idea is that's what the DOL wants you to do, is look at that. So last slide for me to finish up here quickly and stay on time. And by the way, it took me forever to figure out how to do this. So as Fred presses these 2 buttons here, you're going to see a little animation here. So Fred, why don't you go ahead and put this thing in motion? There it goes. So what's happening is everybody's putting the fees before the value side of the equation, and that's not really what we want. You know, if you look at the quality, service, and value side, it makes the entire thing much more meaningful. We cannot solve the industry's retirement readiness problems by lower fees. To state a Captain Obvious moment, lower fees don't help the participant that's not in the plan. So, you know, consistent with the DOL handbook, I saw an advisor in the Rocky Mountain region for a financial services firm. He had a 98% participation rate. He went around to every branch and had everybody contributing 2% more than the average deferral in the financial services industry. And he had 95% of everybody in a model portfolio, which there's some great data from Financial Engines and Morningstar to suggest that automatically diversified portfolios earn higher rates of return. Now, that guy was being paid a higher than average fee, but preliminary calculations showed he was generating $80 million of additional long-term balances for these people. And so, you know, I'm going to end this part with a statement that is, if you do this right, you know, benchmarking becomes a win-win-win thing. Sponsors get protected with a prudent process. Participants have better outcomes. With benchmarking, you get to see your plan versus other plans. And then the service providers are paid fairly for the value that they're adding. I mean, this is not like buy-it rabbit fencing, you know, for the vegetable garden in the spring where all you care about is cents per metric ton. I mean, a good service provider can make a huge difference on the value side. And in fact, again, this is completely consistent with what the DOL wants you to do. So as, you know, give a couple minutes back here to my esteemed colleagues. But as I've looked at all of the suits, it keeps coming back to me this one idea of where's the beef? You know, where's the value? Because it's pretty darn easy to say, well, 2's less than 3 and 1's less than 2. But now you start to say, well, how much is a Lexus worth versus a Yugo? And now it's a little bit of a tougher decision. And you know, a really, really good exercise, both RFP and benchmarking, should bring that value to the forefront. So with that, I will now turn it over for closing remarks. Or best practices, rather, back to David and Tom. I'm sorry.
Great. Thanks, Tom. So Tom and I, in the next 5 minutes or so, are going to sort of go back and forth a little bit. What we thought we'd start off with first is a matter of process. As Tom just said from a moment ago, Tom Clark and I regularly do talk about the process issues. And it's essential to keep these things in mind. I'll tee up a couple thoughts and then toss over to Tom for his thoughts as well. Process, let's actually define what it means for protecting yourself as a takeaway. Number one, from a process standpoint, it is good to know who your actual fiduciaries are. It's too easy to sign documents that come from your different vendors that list the company, your CEO, well, rather than the actual plan fiduciary, whether you have a committee or someone individual, or even the company listed in there. You want to get the actual right party there. Second of all, you want to document things. Litigation is a game of whack-a-mole at this point. Every time there's a new claim, there's a new theory. You need to be adapting, but you should have your process. And I am not one to suggest you need a fee policy statement, a this policy statement, and a privacy policy statement. You need to just have a process. Don't hang yourself with paper. Set up something that works and is simple and works for you, but shows that you've considered what's gone on in the world and you adapt. Don't just set things and forget it, and that can be your record keeper or even passive investment funds. As Tom Clark was going through recent cases, the plaintiffs have turned now to looking at more passive-related investments and whether you should have had them and whether you kept them. And I would not be surprised as we look forward in the future that they will continue to turn in this direction for the simple reason that it was easy to be passive when the market went up. But if the market is choppy, you need to at least be reviewing it. It doesn't mean it's a bad choice, but go through the process. Tom, I'll stop there and see if you have any comments and hand to you.
Yeah, on the issue of process, David, we as lawyers working with our clients, we probably can't say enough what that means. And I'll have 2 points from one from a case and one from a recent conversation. I was down in I think it was Houston, Texas, meeting with an advisor down there. Maybe it was Dallas. I can't quite remember. And we were talking about how a plan sponsor should deal with the issue of fee equalization, in the sense that those in active funds pay more than those in passive funds. And he just kept saying, well, good, we'll just document the decision. You know, I know it's difficult to deal with, and it is. It's a very difficult issue to deal with, because a lot of the technology isn't quite there to deal with it and back up maybe what would be an ideal, perfect ERISA way of response. But he kept saying this comment that, well, we'll just document the decision, we'll document the decision. And I kind of had to stop him and say, hey, listen, it's not about documenting the decision. It's about documenting the process, the prudent process you undertook to show that the decision-making you were doing was in the best interest of plan participants. I know that's longer and it's a mouthful, but it's not just documenting decisions. And what I pointed to was one of my favorite cases out there, which is the case against RJR, the pension committee, Tatum versus RJR pension committee, about how they blindly decided to sell the Nabisco stock after the split off out of the plan, and it became the would have versus could have case. And I wish I could spend 10 minutes talking about the case because I find it so fascinating, but the punchline is, it's the parade of horribles that happens for a plan sponsor when they don't have a process in place, and then they're left to the mercies of the court to decide whether they ended up doing what a prudent fiduciary would have done. Now, ultimately, they came through and they were able to win, actually, back at the district court after the Fourth Circuit sent it back and the Supreme Court declined to hear it. But the key is, they documented their decision. We knew what their decision was. They decided in 45 minutes they were going to sell the stock without further thought. So it's not just about documenting. It's about documenting the prudent process.
And thank you. So I wanted to give each of our panelists a chance to just give some closing remarks. We have some questions, and I thought I would start with Tom Kamak.
Thank you, Fred, and thanks to Tom and David as well for participating in this webinar. My closing remarks are, the Academy Awards just finished, and one movie that won Best Picture was $1 Million Baby with Clint Eastwood, and obviously remember Clint Eastwood telling Hilary Swank to protect yourself at all times. And if there's any UFC members, fans on the line, you saw what happened when Conor McGregor sort of forgot to protect himself at all times. And so this is a very, very different time. You've got to be very proactive about this and not just reactive. And I think service providers that are more proactive than this are actually ahead of the curve versus others who are just sitting back and seeing what happens. And believe me, there are differences between the two. We see it with advisors, record keepers, TPAs. There's some that are very proactive in this case and some that are just saying, well, that's my client's issue. Well, to me, a good service provider should be helping to protect their client. That's one of the foremost things that they should be doing, just like Clint Eastwood's job was to protect Hilary Swank. So, I want to stop and say it's an incredibly different time than I've ever seen in my 32 years. I think people should be very proactive about this, and I think they should be very value-oriented because, in the end, low fees are not going to fix the industry's retirement readiness problem. So thank you, Fred.
Thank you, Tom. I think, David, you were going to go next.
Sure. The way I view it, and thank you all as well for joining us today, my fellow panelists. We spent a lot of time saying how you have to face these challenges. I'm going to try and end on a little bit of an upbeat note. It is not the end of the world. Just because a lawsuit is filed and their lawsuit is settled does not mean that everything is wrong. Don't put too much stock into reading a story of someone that allegedly did something wrong. Tom Clark pointed out earlier his view, and Tom Kamak did the other side about whether people are piling in the logic of the new plaintiffs firms here. But the key is to breathe. The process still matters. People will, in my book, go back to fighting these lawsuits out and make sure your fiduciary insurance is up to date. It can cover the cost of these lawsuits if you're unfortunate enough to get caught, and just watch your process. And if you learn from the lawsuits and adapt and do a good job documenting, and as I said, you don't need to create a million pieces of paper and policies. Keep it simple, stupid. It is a very good logic. But if you do that, it won't have to be hard. I deal this all the time with clients. We have a massive chart of like all these lawsuits that are out here that we maintain and put on our website. And they read it and get scared. But the answer is if you just focus on the process, it's good to know what's going on. It will be okay. I'll hand it to Mr. Clark.
Yeah, and I will also end on a more positive note and key off what my friend Mr. Kamak is saying, that we've gone over the scary stuff today. We did it as sort of a high-level 50,000-foot view of these cases. We've seen over the last decade cases about fees, funds, fiduciary issues. But the reality is that you could have the world's best plan, quote unquote, that would have the lowest fees, the best performing funds, and the greatest fiduciary processes and all the policies that David keeps talking about. And you could have, the greatest meeting minutes in the world, but if those people in that plan don't have any money and they leave after a 30-year career of maybe switching around jobs or going to just that one job and working there for their life, if they walk out with $100,000 in their account balance, and in my opinion, the plan has failed and it's been a miserable failure. And so don't ever forget, to all the people out there, don't ever forget that the finish line is not having the lowest fees or the most reasonable fees or the world's best investments. I like that story that Tom told. It's about making sure that people have money in their accounts. And the vast majority of providers and plan sponsors that I come across on a daily basis are doing their best to try to achieve that. Is there always room for improvement? Yes. And I believe that, the other training sessions of TBSU and TROW and 401k-TV, and we're going to address all of that, but this is just one small piece of the pie. The much larger piece of the pie is making sure people have enough money to retire with.
That's great. Thank you, guys. And thanks to our panel. We do have a few questions, and we do have some time at the end. And one of the questions we did have, and I think I'm going to direct this to Tom Kamak, but our other panelists can chime in, is someone asked that, value versus fees makes complete sense, but are judges actually recognizing that and ruling in favor of the plan sponsors if they have the process in place, even if their fees are the lowest? Or in other words, because most cases are settling, does it remove that argument and force plan sponsors to only focus on fees so they don't have to pay out?
Yeah, I would say that, we're actually involved as an expert witness in a case right now where I can't, of course, give the specifics, but we're basically arguing with some folks that, hey, look, ERISA says reasonable. The Department of Labor handbook says consider more than fees. The 408B2 regulation mentions the word reasonable or reasonableness 49 times and asks for the fiduciary status and the services provided. So clearly, the legal and regulatory framework is there to go beyond that, and the mathematics supports it. If indeed, we don't spend more time on the value side, we're going to reap what we've sown so far, which is 3 is less than 4, 2 is less than 3, 1 is less than 2. Help me with that. So, I like to hear, I haven't read all the cases. I'm not a lawyer. I would turn this over to Tom and David, but I would say that we believe it's going to become more important because it's part of the regulatory framework of ERISA. It is a mathematical fact what we're putting forth. So, gentlemen, what do you think of this question?
Tom, you want to go first, and I'll go after you?
Yeah, the case law definitely says that you don't have any obligation to go to the lowest fee. 408B2 regulations don't say you have to go to the lowest fee, that instead you have to go to reasonable fees. And so how does a plan sponsor demonstrate that process that we keep talking about? In essence, it's funny, we always talk about the 408B2 disclosure rules, but, I'm sometimes apt to call them the 408B2 standard of conduct rules as well. The DOL did a very fancy job of explaining exactly how fiduciaries or responsible plan fiduciaries, as that's defined in the regulation, should be getting the disclosures from the plan providers, looking at the fees, making sure the disclosures meet the regulations, and then doing whatever process it is to ensure that the fees are reasonable and the services are necessary. If you're following that, there is numerous lawsuits that I can point to that said, yeah, okay, you know what, if you have that process in place and you're doing these and you can show that what you did was reasonable, then no, you're not going to get pinged for the lowest fees. One case that jumps out at me is the UTC case on summary judgment a number of years ago that went all the way up to the Second Circuit and affirmed it, and there have been others since then.
And David, before I let you go on that, I have another question that maybe you want to tackle.
Sure.
It says, how do plan sponsors protect themselves from further liability in the event that the consultants who recommend managers are receiving undisclosed back-end additional compensation?
Well, why don't I just jump to that? I know our time will get short here quickly, so why don't I just take that one head on?
Sure, that's what I was thinking. Yeah.
So the answer is that you can protect yourself. You are not supposed to be omniscient. Like, we are handling a very complex litigation with a prior fiduciary who hid the ball, allegedly took money and walked away with it, and other people who are also fiduciaries just never had a clue, and it's working its way through the courts right now, so I'm being very sort of general in nature. The way you do this with some practical takeaways is, number one, you look at your fee disclosures. You look to, and you also ask the right questions. You get the fee disclosures, review them. Don't shove them in a drawer. Show in your minutes that you reviewed them. Second of all, when you do your annual Form 5500, like your annual report, large plans oftentimes will send a letter for the auditor saying, please tell me all your direct and indirect compensation, and please describe everything you have done. That also shows a documented process. Third, what you also do is you do your periodic RFPs, to go back to Tom Kamak's comments earlier. You do your periodic RFPs, and you ask the questions in RFPs where you don't just say, give me your fee disclosure. You ask, do you have any other business relationships? Don't just send me your Form ADV. I need an answer of what are your relationships? How do you tie to other parties? Now, you don't want to overly burden people here, and people are just trying to run a business. But you have a right to know with transparency how people are being paid. And if you ask those questions, document and periodically go back and check. And if they come with a new product, ask what's your tie to it. It's okay for people to be paid. These plans take a lot of resources to run. When the plaintiff's lawyers say it takes $25 a head to record keep a plan, that shows, in my mind, it disconnects the fact that there is no one plan that is identical to another. But if you go through these steps and document the why and how, to go back to the point of you don't always have to be cheapest, the courts will buy it. A number of the cases were dismissed, like as Tom Clark was saying, early. Sometimes they'll even still settle even after a dismissal. But it's not because the courts rejected the argument that you'd had a good process. It's often because of things that are out of sight, out of mind, or just a business and cost analysis. But if you take these steps, you should be in pretty good shape.
Thank you, David. And final question, which I did not create, we actually heard it, was can you recommend one or more seminars for fiduciaries that would provide a somewhat comprehensive background on what we should be doing and how we should be doing it to ensure we're both in compliance and utilizing best practices? And if you don't mind, I will take that because that is the purpose of TPSU, the Plan Sponsor University. We're doing 75 programs this year all over the country. There is no cost to attend for a plan fiduciary, a plan sponsor, and it is focused purely on the education. And we're always open and eager. Do you guys have any other recommendations on seminars or ways for fiduciaries to educate themselves?
Well, I'd be remiss to name anybody other than you on this call, Fred. So all will be good.
Very good. Well, we'll leave it at that. And as the moderator, I will get the last word. First of all, I wanted to thank our panel. This is really an incredible group, and thank you for your time and your expertise. We tried to make this as simple but as practical as possible. And we do also want to thank Fiduciary Benchmarks because they did sponsor this. And they were so passionate about this subject, and Tom Kamak is so passionate about really trying to help people and help plan sponsors to do the right thing, that he felt so strongly that he just stepped forward. And we do appreciate that because it does take, money and resources to do this. I will say, the final thing, probably, we talk about a documented, prudent practice. I would say, even going back, hiring the right third parties, whether it's starting with your advisor, starting with your CPA who's doing your audit. 60% of plans out there still have an advisor who we would consider, less qualified. It's moving in the direction maybe 5-6 years ago was 90%. The DOL just came out with an estimate that said that 40% of the audits that they're reviewing are really done by CPAs that don't specialize in this and maybe have a relationship. And that can be a big problem, because through the audit process you can find a lot of these errors and mistakes. And then, finally, too, there are third parties like Fiduciary Benchmark who, going through a relatively painless process to do a benchmarking, and they've amassed, I think, over the last 8 or 9 years, incredible databases that you can use, and certainly prudent to help you to do that. So I really applaud the work that you've done, Tom, in doing that. So with that, I will encourage you to watch 401k TV. We try to educate you every day on, for example, there was an article and a video from a plan sponsor about fiduciary insurance, and relatively inexpensive and how you get it. And also, we hope to see you at a TPSU program and more of these master classes. So thanks again very much for your time, and thank you for the panel. Really did a great job. Appreciate all of your work today. So thanks, everyone. Have a good day.